Welcome back. This is Daybreak, and thank you for staying with us. The hashtag on X is Daybreak. The SMS code is 22422 at Citizen TV Kenya and at Ayub Abdikadi. Yes, Bob, you had a point, please.
Yes, I wanted to pick from where Mheshimiwa had left and reminded us of the famous case of Marbury versus Madison, celebrated American case. And I wanted to remind him that also what Justice Marshall did state in that case, and in view of the Constitution, in creating actually what we are also talking about, the aspect of judicial review, the aspect that you can challenge the actions of other arms of government, action by the executive, action by the legislature, in the sense that whatever is done, and I think you made that point, must be done within the confines of the Constitution. Whether it is planning, whether it is execution of a project, that must be done within the confines of the Constitution. And that is why Justice Marshall said, a law which is repugnant, and I might paraphrase that and add to an action, a misaction that is repugnant to the Constitution is void. And that is why I think Kenyans also designed, and I join hands with the two gentlemen in the aspect of you cannot have institutions that are only independent but not accountable. And that's why in our design, you find that Kenyans did secure, and they did a good job in securing the independence of many institutions, but primarily the judiciary. You mentioned the JSC, how it was revised considering what we had in Section 61 of the previous Constitution, where the president, was literally running the judiciary, to what we have now. And we've seen some fruits from it. But also, there is accountability, in this the JSC, in the expansion of its membership, the powers that it has, and we've seen many judicial officers come to face this institution. So I think these are the things that we should be looking at and using, because these are the railroads that we laid out and said, yes, we are going to give this very important institution and the people that play the roles within them these powers, this protection, but also Kenyans, on the other hand, designed and said, we will hold you accountable in this way. And so that is why whenever anyone has an issue that touches on the accountability of a judge or any judicial officer, then we have to use the right channels. Because if you don't use the right channel, then we'll be going to what Mheshimiwa talked about, anarchy. We'll be running the country through public opinion, public rhetoric, which cannot be tested, whose veracity and truth cannot be accountable. And that is why also these projects, programs, plans that government and especially executive undertakes, if any Kenyan feels that there is something questionable, they have their right of day to go to the courts. And the other thing I want to say is that when we throw these blanket statements that the judiciary is corrupt, and I want to bring it within our current political context, and I think also what Kenyans are seeing in terms of, if I may use the term, hypocrisy, because within the past 12 or 14 months, and especially after the judiciary delivered
the presidential petition
around the presidential, we had now sides have changed. The government was out praising the judiciary, isn't it? Kenyans remember that. Whereas the opposition was out vilifying, or the side that lost, vilifying the judiciary, almost using the same rhetoric, corrupt, pocketed by the executive, etc. Now tables have turned. And I think in some way, and the judiciary is not perfect, I agree with to that, but in some way it sort of shows that its independence is somewhat intact, because at the end of the day, if you're being fried, by both sides, meaning that you're not making anyone happy. It means that in some sense you are delivering your obligation and your mandate in a way that is fair to all. But not to say that there are no problems with the institution. But if they hear the ranks of Mheshimiwa here fatally, losing hope around the institution, when they hear the leader of the nation in the presidency in a fatalistic manner also pronouncing as if there is nothing that can be done, and we know these are people with vital information which can be directed to the right institutions and processes, then I think, unfortunately, if we lose any of these important arms of government in terms of how the public perceives them, it is not only the judiciary or the legislature that loses, but it's the entire edifice of the state. Even may add, some of this rhetoric also must be checked in the sense that, for instance, the judiciary is the guarantor of let me, cut to the chase. We want investors to come to this country. Investors will go to a country where they know rule of law is respected, where they know you can enforce contract, So if you are sounding out, and especially from the high echelons of the state and government, if your rhetoric is to the point that we do not have an accountable judiciary, we have a corrupt judiciary, and on the other hand, you come out and invite investors to come to this country, then you're stepping on your own toes. Okay, yes, Honorable Farah. In as much as you may be speaking truth to your opinion.
Yeah, we are in agreement on one. Let's put certain facts to rest. Okay. All three of us in agreement that...
All four of us.
All four of us. That judiciary is not different from other institutions of the country. There is massive corruption in there. Massive corruption in there. And I'll tell you, I was shown the case of somebody who was trying took a civil matter to court to claim for a certain amount of money. And the magistrate, because this is a parastatal, this is a government body which the presumption is that they have got very deep pockets. And the amount that the lawyer is asking for is more than twice what he was supposed to recover. You get my point?
You mean his legal fees?
His legal fees. Okay. And of course that is in agreement with whoever was giving him that contract, whoever was giving him the brief must have been in agreement with that. And then you look at this kind of pending bills right now for lawyers in the country. It's crazy. It's crazy. It runs into billions and billions of shillings. And there is no way in which these things can be taxed properly, and you can say no. LSK can come out into the front and say we cannot accept this. The judiciary will say we don't accept this. This is an abuse. You know what I mean? You're denigrating and destroying the reputation of the institution itself and the profession. I agree with them. Wait for the piece of legislation itself to be enacted. Let that now come before you as the courts, and then strike it down as unconstitutional. But you cannot go and say that in Parliament cannot, enact this piece of legislation. Let them go ahead. They have the independence to do that, including enacting an unconstitutional law. But then it will come before you. When it comes before you, there you are. You say it's unconstitutional. Strike it down.
Okay, to be
that is the way, that's the practice.
Which is the example that in this case you want to give? Because in the case of the finance bill,
I think is it
the omnibus question?
The major complaint is the stopping of the deliberation.
Absolutely, you cannot stop the deliberation. You can't stop Parliament. You can't stop Parliament from conducting a parliamentary process. You can't. Actually, you wait until the process itself is concluded. Let them go ahead. Let them pass a piece of legislation. Let even have a presidential assent. Let it appear before you, and then you strike it down.
However, it may...
Hang on a minute. Okay. Hang on a minute. You strike it down. That is how it is. That is the independence of this institution to make laws without any interference from any other arm of the government. You get my point? Even if the president is unhappy with that, you can override him with, you know what I mean? There's an overriding what they call a majority. And the president can refuse to assent to a law, a piece of law. Parliament can override him. You know what I mean? And then the matter comes again to the judiciary. When it comes to the courts is when you strike it down. But you can't tell Parliament. You cannot carry out a parliamentary process. It's like Parliament right now coming out and saying through a resolution of the House, the courts cannot hear this and this matters. You get my point?
Okay.
It works the other way around. Hang on a minute, let me tell you.
Okay.
It works the other way around.
Okay.
When a matter is before the courts, you see, this independence itself is that nobody should interfere with the independent process of an institution or rather one of the arms of the government. That's why if a matter is before Parliament, if a matter is before the courts, we cannot debate it in the House because it's sub judice. It's sub judice. But you see, there has to be what do you call a reciprocal process in which the judiciary gives Parliament its freedom and waits until this matter comes before it. You see, what Parliament can do, I'll tell you.
Yeah.
A bad law, a repugnant law, whatever it is, Parliament can determine that and say, okay, we remedy by repealing it, amending it, you know what I mean? Doing whatever you have to do. And then finally it becomes a piece of legislation, it's law. At that time, the courts cannot say this is a repugnant law because it's there, it's constitutional.
Okay.
It is, you see, everybody has got to be able. And then when it comes to the executive has a limited time to execute its own programs and projects. Hang on a minute, let me tell you. This is the reality of, we are living in what you call, there's something called sociological jurisprudence. We are living within a society. We are not living in isolation there in some kind of a utopian place. Everybody is supposed to be given a certain, like I'll tell you, for example, I have programs in my own constituency. And you know, anybody can run there to the courts, pay something little out there, and get conservatory orders. So you stop a program. That program itself is probably a concessional, what do you call a conditional loan. It has a certain limit of period, and if it stays for too long, it is going to be withdrawn. Okay. And the same thing also happens, let me tell you, when it comes to investors coming in. The reason why investors are not coming in, the reason why investors are wary about investing in this country is not because the executive is attacking the judiciary, no. It's not because Parliament is attacking the judiciary, no. Because there's a corrupt judiciary and you can have your matter out. Like, let me just finish.
Okay, well, I mean, a lot of mix-up. Okay, a lot of mix-up because it's largely, I mean... You
can have your matter up there in the court for the longest.
Yeah, okay. Yes. Largely due to economic policies because also the control of budget talked about that and why there's the sudden flight from the Kenyan market. You talked about time frame. We'll talk about that, yes, but Bob, you had a...
Yes. I just a small point on the process of legislating.
Yeah.
We are talking as if it's the judiciary. Our system is that the judiciary is the one that calls these matters to itself.
No, it pronounces itself to that matter.
Yes.
And tells Parliament you cannot enact this law. That's wrong.
After being invited.
Yes.
By Kenyans who present petitions.
No. They wait until the matter itself is concluded and then they deal with it at that time.
I think, Mheshimiwa, you are failing to understand one thing.
The independence of the legislature is for it to be able to act.
However, let me make this point.
Enacting an unconstitutional law.
Let me make this point. Because
it's even concerning that Parliament can discuss something which they think is wrong.
And Parliament is delegated of its mandate from the people. So a Kenyan, and there's a process that has been laid out in the Constitution and other laws of how Parliament and parliamentarians conduct themselves, how we legislate. So a Kenyan cannot sit and say, for instance, a law is being created and Parliament does not call for, or a county assembly does not call for public participation. A Kenyan is not invited to wait until that law is finally enacted so that they can go and stop it. And the courts, I think, have a right to say, okay, we have evidence here to show that this part of the process was, or this aspect is not properly being conducted. So why wait until the end? Spend public money, because these processes are not also done free of charge. It is public money being expended. So a Kenyan has a right, a constitutional right, to go and say, hold on a minute. We have 5 steps. Step 1 has not been undertaken correctly. Please halt this process as of now. So in that context, I think Parliament can be stopped from continuing to perpetuate an unconstitutionality. So that's the one point. The second point is this, and I think it is important when Mheshimiwa's point, because it goes to the broader aspect of electoral politics, electioneering. It is Andrew Cuomo, the former New York governor, who said that you know, politicians will campaign in poetry. but they will administer in prose. And what is important in this, and especially for us Kenyans, and a lesson we should take, is that when politicians and parties come to us during campaigns and pronounce and make pronouncements and make promises, what we need to interrogate is how those promises are going to be executed. What is the law you're going to come up with in executing those promises that you're giving? Our president here has told us how it actually advised, how they provided the opinions around some of this legislation before enactment, that we think if you go this way, this is constitutionally sound and you will succeed. But this was ignored. But what I'm trying to say is that these are some of the things that going forward, we as Kenyans, we will be asking our politicians. Even Mheshimiwa here is saying his projects are being delayed. But asking, when you come up with a project, when you come up with a promise in a manifesto, we should be asking, what is the wherewithal? Constitutional, legislative, but also, where are you going to get the funds to implement your projects? And I think when you look at other countries, when they have debates, presidential debates, or in the UK, you know, parliamentary prime ministership debates and leadership contests, you find that the debate is around those crucial issues. You say that you promise that you're going to put up these roads. The law states this. How are you going to do it if the law is contrary to what you're promising? Which means that you have to explain that you will start from probably changing the legislation. Where will you get the money?
Comes to the question of compliance.
Exactly.
With the law.
So it doesn't mean that everything you have in your manifesto must be. And if you want to implement it within the right time, then make the right plan.
Okay, yes, I'll come to you. Okay, you had a point earlier on.
Yeah, there's one thing that is extremely disturbing in this discussion, that if I am elected president and I have promised something, irrespective of whether it complies with the law or the Constitution, I have given a promise and I must implement it. And that is actually what the president and Mheshimiwa here are saying, the limited time frame. But let us locate where the problem is. The problem is that the government is given the correct legal advice, but it ignores it for political expediency, because they want to implement something for a particular reason, and then thereafter come back and blame the judiciary. But who is the executive blaming? It is not just blaming the judiciary, because what happens is that Parliament will not enact the law, and then the judiciary will go and pick that law and look at it and say, no, this law is unconstitutional, and strike it down. Someone will have to go to court.
Litigation.
So what is the president doing? The president is saying the Law Society of Kenya corruptly engages with the judiciary in a corrupt enterprise to ensure that they defeat the law. And it will not just be the Law Society of Kenya. It will be another person in Kisumu, another person in Isiolo, another person, so that anyone who goes before the court and seeks and obtains an order, having persuaded the court that an order ought to be given in those cases, then as long as they affect government project, then those people are in a corrupt enterprise with the judiciary. And that is where it becomes, it gets absurd. Because now you're now saying it's not just the judiciary in itself, but also the litigants. And the president has been very clear about it. Now, when you listen to, for example, Mheshimiwa Farah talk about the question of pending bills, I know a lot of lawyers who have done honest, diligent work and are owed millions of shillings or thousands of shillings for work that they have done.
You also know? You also know?
No.
Others who have taken in their billions for what? For things that are basically inflated?
No. Because you see when I usually find this comment whenever it comes from anyone who understands the legal process to be extremely ridiculous. Because there is a law that regulates how an advocate can charge. And for us, we are able to look at a fee note and say, this one is justified, this one is unjustified. Where a fee note is unjustified, the process for setting it aside is very clear in the law. And I have participated in the process of verification of some of these pending bills. And most of the instances, they are justified.
Okay. Well noted.
Yeah.
Honorable Farah, I'll come to you because this is very key to point out. And it is, on one side, the allegations of corruption and the judges whom the president accused of having teamed up with his political rivals, and the litigants who, after the president's New Year Eve speech, also the Kenya Kwanza leaders, and by extension some in the opposition, even in the aftermath of the Supreme Court's upholding of his victory, have largely accused the parties of. For example, Article 258(1) talks about every person's right to institute court proceedings claiming that the Constitution has been contravened or is threatened to be contravened. In case that is not clear to the political class who seem to be using the judiciary as a punching bag, 22 again, Article, subsection 1, every person has a right to institute court proceedings claiming that a right of fundamental freedom in the Bill of Rights has been denied, violated, or infringed. Again, Article 23(1), the High Court has the jurisdiction in accordance with Article 165 to hear and determine applications for redress of a denial or a violation of infringement or a threat to a right of fundamental freedom in the Bill of Rights. Not once, not twice, not thrice. Litigation is provided for in law, yet there is a general political statements made by the political class to brand and to paint in the broad brush Kenyans who are moving to court as enemies of people, yet they have the constitutional right to do so. It's not a privilege, is it?
Ayub, I want you to really sit back, meditate, and listen to what I'm telling you. When a matter is in Parliament, why do you make an assumption that this law is going to be passed by Parliament? Let's say somebody is trying to push an unconstitutional law. The matter is just before the House. Instead of going out there and saying that this cannot be passed by Parliament, how sure are you that this thing cannot be shot down in Parliament by members of Parliament? In other words, you're preempting the role that was given to parliamentarians for them to determine these things, to see what's unconstitutional, to see what basically is not right, what infringes on the Bill of Rights and the rest of them, and for them to shoot it down on the floor of the House. But you go to court and you say, Parliament cannot debate on this. How many things that are there that we debate on every day? There are many things that are there we debate on every day. Supposing you have to subject all of them to the courts to determine, then the courts will be deciding for us what we can deal in and what we cannot deal in. That negates the very principle of the independence of the different arms of the institution. But when it comes to you, if Parliament in its own wisdom passes an unconstitutional law,
yes,
then it's going to be brought before you.
Okay, and we had
hang on a minute.
The 3 points I mentioned out.
I agree with you. I agree with you. You see,
and that is what
judicial review is allowed.
Okay.
Judicial review is allowed, in which the courts can determine the constitutionality, the legality, the legitimate, a lot of things of a piece of legislation. But judicial activism is basically what we are saying we should stop. Yeah, you get my point.
Ayub, let me agree with Mheshimiwa on one thing.
Yeah.
That in the ordinary course of things, there is a doctrine of restraint.
Absolutely.
When it comes to matters that are before Parliament. It does not mean that a judiciary cannot stop Parliament from interrogating a piece of legislation.
A piece of legislation, not a bill before the House.
Let me make my point.
Yes.
It actually can stop Parliament from, can injunct Parliament from considering a bill. But I'm saying that in those cases, there is what we call the doctrine of restraint, the doctrine of ripeness, that it may not be ripe.
Absolutely.
So that is the general principle. But what I have a problem with is that in the instant that the court does so, do not say that the court has done so corruptly. So that we agree that Parliament should be allowed to carry out their legislative authority without interference from other parties. But in the
okay,
because you see, there is always what you call the general rule, and then there are exceptions, and parliamentarians know this. The general rule should be that Parliament should carry on its legislative function unrestrained. We wait for the final product.
Absolutely.
When the final product is out, we examine it.
And interrogate at that time.
If it fails to meet certain constitutional principle or other legal societal principles, then we challenge it. That is the general rule.
And that was the point with which I came to Honorable Farah Malim. After you have addressed your point on the same, there seems to be concurrent.
That is the general principle.
Yes.
But what should never happen is that if the court then goes against the general principle, for someone to say that the court has gone against the general principle because of corruption.
Yeah, and that is the point.
That is the point that we are making,
You see, we're getting together somewhere. The point is, these are the independent arms of the state. Allow each one of them to function independently. Allow each one of them to deal with these things in ripeness, as you put it. Wait for it at your time when it comes before you. For example, as a speaker on the House, I was a deputy speaker there. I do not anticipate anything. I wait. You see nothing, hear nothing. You wait until the matter is raised by a member of parliament on the floor of the House. Then you rule on it. And that's exactly what judiciary should be doing. Judiciary should not engage in the activism of trying to, stop parliament. I do agree with you. It's not always corruption that's there, but the presumption that they have battered into an area. You cannot legislate from the bench. You cannot run the country as an executive from the bench. You can't decide. Hang on a minute. Let me just. You wait for me. I think if we listen to one another very well, we will be in concurrence because we're trying to get this country better. And the best way to get this country better, is for us to understand where the borderline is for every institution in there, and for every institution to be able to optimally operate. And if it's basically does, you see, we used to have what was called the parliamentary sovereignty ourselves. I think we got rid of that. Yeah. We had the parliamentary sovereignty, where Parliament basically was. You see, even now, there's an element of parliamentary sovereignty. Parliament can interrogate right now how the judiciary uses its own money. Definitely. It uses its own things and how much to be allocated and all those things. The only thing is that in its own execution of its own mandate, Parliament cannot say that the judges erred in this and that. So my position is that let us allow a seamless operation of let us stop any form of activism on the part of the executive, on the part of the legislature, and on the part of the judiciary itself. I was telling you before, I know you are a bit in a hurry to say something, but you'll have the moment to say it.
No, I thought you had finished.
You see, it's the final body that's supposed to arbiter on these things. You can deal with an alcoholic father in the house, you know what I mean? But when you have an alcoholic mother, then you have a serious problem. You get my point? This institution is the one which is supposed to have that massive sobriety, massive everything else. It should be the final recourse, the final arbiter of everything. But when this one becomes now drunkard and drunk with something, you know what I mean? Either with power or with corruption or with any form of activism, we're in trouble. So my position is that no, we are not saying that judiciary. We had a moment when Justice Ringera came out and said that the entire judiciary is corrupt, and let us go right now and do the Ringera Commission. You remember that? Why don't we now? How many people write about that to say that we made a mistake? This country made a very fundamental mistake of gone to what do you call it, a scale because of doing these things and infringing on the independence of the judiciary. No, in itself, so many corrupt judges were thrown out of the system.
42, and I think then 2 plus 250 something plus magistrates.
Absolutely.
That is the Ringera Commission.
That's the Ringera Commission. And nobody talks about it right now because they all know everything that was said in that place was basically right. Okay. Now, we're having a rot also in the judiciary right now because independence, we created a constitution, Constitution 210. The idea was that we liberate ourselves from executive despotism and dictatorship. But we have ended up creating every arm of the government becoming a despot in its own rights. You see what I mean? Right now, have you watched the members of parliament?
Okay.
Have you watched? Can I just finish?
Okay. I'll hold him to account because Honorable Farah, you have deviated away from my question.
Can I just say? Did you watch now members of parliament saying, we must get our money in there?
If you don't get it,
or CDF, If you don't get it, no. But you see, that's not how parliament should act. You know, we have a house out there. But we do understand all the problems that are there. But you don't threaten others in the executive, or what do you call it, in the judiciary, because you want to get your way around. So when you create, we have devolved. We devolved what you call corruption all the way to the counties. The counties are right now the most corrupt. We have devolved, we've created what you call the three arms of the government, give them independence. That independence has given them impunity. They are acting and operating with impunity. Parliament, you see, Parliament sometimes would say, I know members of Parliament who would say, we're not going to pass these things until the ABCD is not passed. It's no longer the interest of the country. So what I'm trying to say is that the judiciary should be the institution that has got to be beyond reproach.
Okay, thank you.
It is not now.
Okay, thank you, Honorable Farah. Well, I'll hold you to account again on the questions I raised, but Bob, you have a point.
Yes, just hot on the heels of what Mheshimiwa said, and I want us not to forget this point. We've talked about parliamentary sovereignty or judicial sovereignty or...
There's nothing called judicial sovereignty.
No, I'm just saying. It's a term. No, I'm saying you've talked about
parliamentary sovereignty is there, but not judicial, not executive.
No. I'm just using the terms as a matter of speech. No. Yes. I'm using them. I know what I'm saying, Mheshimiwa.
Okay.
You talked about these institutions being despotic, isn't it, in their own way? And in some sense, without getting to the aspect of despotism, it is by design that these institutions have been created within the framework that we have. And I was coming to this point. We are talking about these institutions as if they derive in and of themselves. The one who is sovereign in this country is the Mwananchi. And it is the Mwananchi who has the wherewithal at any time, by the way, at any time, to invoke the mandate and to ask any of these institutions to act as per what the Mwananchi wants. So a Mwananchi, even with the principle of restraint, a Mwananchi has the right to walk to court. And that's why, as you are reading, even the aspects of a threat to the Constitution, a threat to human rights. If where I sit, I feel that I'm seeing this process beginning and going on, but I can smell a rat. That is why the Constitution does not give timelines, that you can only come after the first reading. You can only come after the second reading. You can go at any time. And yes, the court, in as much as there is a general rule, will examine that with that in the backdrop and then state according to what has been provided before it. And that's the point I was making, that the judiciary does not proactively go and look for these cases. It is the Kenyans who use the powers they bequeathed and affirmed for themselves in the Constitution who go to any of these institutions, even to Parliament. Please pass this law. Please stop this law. Please amend this law. Kenyans have the right to petition Parliament to do this. So when we discuss some of these issues and when we are laying blame on these institutions and the despotic nature that has been created using that term, because they are not despotic also, but I understand what you mean, and that's what I was meaning by judicial sovereignty in that sense of using the term. The design is that, I don't know why people think these institutions must work in chorus. You know, they are not designed to work and sing in chorus. In fact, they're supposed to lock heads. They're supposed to examine, check and balance each other, so that at the end of the day, the decisions that are made are made in favor of the Kenyan who is the owner of these institutions. So let us stop talking about the legislature, the judiciary, or the executive. And I think sometimes Mheshimiwa mentioned it, that we have not disabused our minds from the previous system we had. And I agree, we had about 50 years of it. We are only 14 years now coming into this year, into this new dispensation. So those are old habits. The old mindset is yet to depart from our psyche. That is and that's why sometimes you'll hear the political rhetoric from the executive, the rhetoric from legislators. If you examine it, you can tell it's that old mindset. But if we remember that we did design a system where these arms of government only coalesce and work within the confines of the mandate that the Constitution and Kenyans have given them, and there is a checking and balancing system, then when I hear them locking heads, and especially on matters that are constitutional and legal, then we have the right framework.
Thank you. Yes, coming to you, Wakili Daudi. I mean, the president also yesterday, to quote him, he said, it has been suggested to me, he meant himself, that the previous regime had a budget to bribe the courts, but I will not spend a single cent on bribing judicial officers. Given what we are witnessing at the moment, I mean, it puts under the spotlight, is it the Attorney General who is the principal legal advisor to the government and its institutions, and why then the sudden disagreement with many of the government's cases when it comes to court and the dispensation of and the determinations made to that effect? I mean, does it not raise more questions about the AG's office when it comes to the government's court cases and the subsequent losses when it comes to big projects like the housing and the health?
That is true, and the position that the Attorney General holds is one that has been examined in a lot of these issues, because one, he's the principal advisor to the government on all these issues. But also, Ayub, the other critical thing is that the Attorney General, by virtue of his position, also sits in the Judicial Service Commission. And so that, therefore, he is the president's voice in the Judicial Service Commission. Where there are these issues, he is the one who is supposed to speak in the Judicial Service Commission and express to them the views or the displeasures or the positions that the president may have. But what we are witnessing, in my view, is a situation where one arm of the government is unwilling to operate within the confines of the Constitution. Because whatever complaint they may have with the judiciary, they have enough mechanisms within the law to deal with them in a manner that supports the statehood. What is the statehood? The statehood are actually the three arms of government working in harmony with the president at the top, promoting national unity, promoting constitutionalism, promoting the rule of law. And that is what is critical in this discussion, so that we have actors such as the Attorney General who are supposed to advise on the law, to advise that if you do this, this is what is going to be problematic. If you do this, this is going to be problematic. If you do this, this is what is not going to happen. If, for example, the court has given an order that you disagree with, let us go to court and challenge that order and raise that question. And so therefore, if, for example, the executive is feeling aggrieved, or parliament is feeling aggrieved, that the judiciary is unnecessarily stopping them from enforcing they have a platform that they can raise that issue at the Judicial Service Commission, and to raise that issue and to say that we feel as the executive that this and this and this is happening within the framework of the independence of the judiciary. We respect your independence, but we feel that there are certain things which are being done or not being done that. And that is the reason why the executive has membership at the Judicial Service Commission, so that those issues can be discussed within the confines of the Constitution. Because there's one thing that we have to accept here, that the independence of the judiciary comes with what we call decisional independence. And so that therefore, a judge looking at a case before him would be able to determine whether this meets the constitutional principle or not. They do not necessarily have to be right.
Absolutely.
That's the thing. They do not necessarily have to be right. And that's why we have an appellate mechanism, so that if a judge is wrong, having exercised his mind independently on an issue, then that issue can be reviewed elsewhere.
Okay.
So what I want to say is this, that the history of this country is extremely important. We always have to examine and say, why did we enact certain things in our constitution? It is there. And when it comes to interpretation of the constitution, the first place you go to, I think we all know this, is what is the history of the country?
The intention of
what was the intention? And whatever determines the intention is actually the history. So we've come from this past. And where we are, and why we are concerned right now, is that we are seeing tendencies that wants to take us back to an era where we have said, as a country, we are not going back to. So, and for me, the thing that makes me happy is that the executive is actually unhappy about decisions that are being made by the judiciary. And I want to urge the judiciary of Kenya to continue making the executive unhappy, uncomfortable, making parliament unhappy and comfortable. Because as long as they are doing it within the constitution, as long as they are doing it guided by the law and guided by the constitution, they are doing the thing that they are supposed to do, and for us, we will support it. But if they become unaccountable, then we are going to challenge.
Well provided for, I mean, the mechanisms that you've talked about, and one of, Honorable Farah, just order. One of the key sticking points when it comes to why we walked away from the old order was, for example, to forestall situations like what happened in 1968 here, when President Jomo Kenyatta fired the then Chief Justice Dennis Farrell, who reduced the sentence given to Bildad Kagia from 1 year to 6 months, because Kenyatta was simply disappointed by the reduction of the sentencing which was given to Bildad Kagia just some 5 years after independence. But specific question for you, Honorable Farah Maalim, here. I mean, you talked about Parliament and the need for it to exercise its independence, for example, doing legislation, oversight, and also the key question of representation. But then why do you think, and what do you think informs for a mwananchi to move to court on issues like the cost of living, which they can easily petition Parliament? Why are the Kenyan people distancing themselves away from you, the parliamentarians, and seeking solace in the third arm of the government?
You see, let me tell you some things. I'm happy with the chairman of LSK. By the way, judicial review is a piece of legislation that's there, an act of Parliament. You don't have a judicial review on a bill. You get my point. You can't have a judicial review on a bill. The bill has got to go through the process and become an act of Parliament, and then you have a review. Then you will find the lower court pronouncing a decision, the Court of Appeal pronouncing a different decision, the Supreme Court pronouncing another decision. On the same matter, sometimes you'll go to a judge in Kakamega, or you go to a judge in Kisumu, and you get different, what do you call, decision on that. The judiciary, even through what they call the JSC, does not have an internal mechanism for it to interrogate and review matters that come out of it, rulings that come out of it. For them to say, here, either there was such a dearth of the understanding of the principles of law itself, or there was influenced by something else for them to reach this decision. So you have literally, for lack of a better word, a rogue judiciary where any judge will do whatever he wants, and that's not subject to review except through the appeal, and then the appeal against the Supreme Court, and all of them are not in harmony. Let me be honest with you. None of them is in harmony. For example, when somebody came out there and said, blatantly, openly, in sight of the entire nation, everybody knows so-and-so looks like he has a degree, and everybody knows that he does not have a degree. What did we do to that Supreme Court? What is the avenue open to us for us to get rid of that Supreme Court? Because here is a Supreme Court making such an outrageous ruling on a matter. And everybody says they took money. You get my point? Do we have any remedy? No. We don't have a remedy for that.
How about if that money?
Hang on a minute.
If money exchanged hands.
No. That is always what people will say when something doesn't look right.
Yeah.
People will say what influenced it.
Okay, but we are far beyond allegations. This is it, Honorable Farah Maalim. Because
this is factual.
Okay.
This is you who don't have a degree, and a Supreme Court judge says you look like you have a degree.
Thank you.
And the nation just sits back and watches it, and the same Supreme Court judges are still there.
As you make that, I don't want us to move away from the substantive debate of, having a body like the Judicial Service Commission. If money had exchanged hands, why not then petition the Judicial Service Commission?
You know, what I'm trying to tell you is Judicial Service Commission does not have a mechanism to bring either the Supreme Court or a judge of the Court of Appeal. We don't have that. We have to look for that mechanism now. We don't have a mechanism for them to interrogate and tell him, how did you reach this decision? And then from learned minds, brilliant learned minds, to say, no, you erred in this. Are you getting my point? We don't have that mechanism in here. So every judge is basically a law unto himself or herself.
No.
Can I just finish?
No, because
unfair to say that. You see, every judge is not
that is wrong, because there's one thing that we have to accept and understand. That the aspect of judicial independence also relates to decisional independence.
That's what I'm saying.
Yes. What you are
that decisional independence has got to have an internal mechanism for review itself.
No. Because the moment you get into decisional independence, that is when you undermine the independence of the judiciary.
That's the point. But then the judiciary within itself has got to
I would agree with you that where a decision
how do you erode the dignity and the trust of the people when you make things certain decisional, what do you call, independence, that are seen in the eyes of everybody to be faulty?
And Honorable Farah Maalim, because I had a question about the people, you have mentioned the people, and again, diversion away from the question. Why then would a Kenyan, a mwananchi, move to the judiciary and the courts on issues like the cost of living, which Parliament can substantively handle? They can easily petition you.
Nobody.
Why do you think Kenyans hold you in very low esteem when it comes to you parliamentarians?
Let me now tell you something. When you have a government, whether the economy does well or doesn't do well, whether the cost of living goes up or does not go up, the brilliant, provisions of the Constitution, right to this, right to that, these are all, basically a presumption that the nation is going towards that. But there's no guarantee that you'll be given a right to housing, and because you don't have a house yourself, the government must give you a house. You get my point? You see, there are a lot of things that are there in all constitutions. When in America, when they say, we the people, do you know the history of the American Constitution? There is no place where the people were involved. No place where the people, when they did it in Philadelphia, it was just that handful of property, slave-owning, brilliant lawyers, advocates. These were the people who came together and created the Constitution. But they say, we the people. You get my point? So these things are always there. In any nation, you will say, we the people. And it say the sovereignty of the, rests with the people. The people cannot exercise sovereignty. How do they exercise sovereignty? As the masses of Kenya. Is there a way we can all come together and decide whether we want to have a good relationship with Uganda, or we want to have this kind? No, the sovereignty itself is exercised through its own elected, what do you call it?
Okay, that is the delegation of that mandate.
Now, there is the sovereignty of Parliament itself, which I think we had an absolute sovereignty of Parliament before we had this Constitution in place itself. Sovereignty of Parliament was there. Because Parliament, as you're putting it, Parliament basically was that's why the President, the executive controlled Parliament those days. They controlled Parliament because everything was in Parliament. Even within that, Parliament itself can be interrogated by having the judicial review. And I was talking about the difference between the judicial review and what you call judicial activism itself, where the judiciary tries to legislate from the bench. Whether the judiciary tries to become an active member of the executive from the bench by stopping programs that are there. Let me tell you, what is legal or constitutional about having a tarmac road from here to Garissa, for example? What if procurement process was not followed as duly laid? Look, these are civil matters that essentially will be, you get the remedy for
which
that.
Is a very critical
Hang on a minute. Yeah. You can't stop the project. What you do is that you go to court, and once the court is satisfied that the process was poor, then you get your own, what do you call, you get your damages. You get my point? That's how people go to court. To be given, you sue. But you can't stop.
Isn't that what people are doing?
Yeah, but they're not stopping government programs and projects. Nobody has a right. Hang on a minute. Government has a right to exercise its own mandate and authority up to and including taking us to war. The president on his own can say that we're going to attack Somalia.
No,
or attack Tanzania. Just a moment. Just a moment. Hang on a minute. Hang on a minute.
It's subject to parliamentary checks.
Hang on a minute. It's subject to parliamentary ratification within a given period of time. But initially he has that. The Congress in the U.S., the president of the U.S. has a right to declare war on a country. But Congress can hold the pass and later on deny him that possibility of him, once they hold the pass, which means the forces cannot fight because there's no money.
Which is an extra layer of check.
Yes. So basically, when you have an executive, you allow the executive the space itself to perform its mandate.
Correctly, within the Constitution.
No. You go to the court later on and say
No. You know, may I use...
Hang on, You see, we're not... You go to court and you strike it down.
Okay.
You know, I liked the analogy, if I may.
Okay, allow me to be the arbiter.
I want to be seriously mature on this thing, and I'm trying to get people to think in this. In any developed democracy, there's a way that every arm of the government acts within its own mandate. But then if there are issues, they come out later on. And the matter itself. To the extent.
After you've lost trillions of shillings?
No.
Yes. Order. Let me now put this to a conclusion.
The British lost trillions of shillings in the war in Iraq. Now they have found out that Tony Blair did a mistake. Now they're talking about whether to take him to court himself. But they couldn't stop him at that time.
Thank you, Honorable Farah.
Yeah.
Allow me to be the arbiter now. You talked about which ought to be fair. And to be fair to all of us, then everything must be in compliance with the Constitution.
I am in compliance with the Constitution. Don't tell me I'm not in compliance. I'm just saying, seek the compliance at the right time. Allow every arm of the government to act independently. And then interrogate it later on.
Let's now sample the feedback. 5, because there are many at the best interest of time. Let's have what you're saying on the X handle at Citizen TV Kenya and at Ayub Abdikadir. The first one from Engineer Lazaro says the current tug of war between the two important arms of government showing the nation take the wrong path of anarchy. KK government scaring investors with their rhetoric utterances. The president himself seems to be advocating for lawlessness. Daniel Masinde, 78, says that Sindani says that there is corruption in the judiciary, yes, but there is the executive and legislature calling the judiciary corrupt. It's like duck pot calling duck pot. Duck. The executive and the legislature must fight corruption in their ranks before pointing out at the judiciary. Babu Michel K says the president, Kimani Ichung'wah, and all the KK sympathizers, according to him, who are shouting on rooftops about judicial corruption, need to do a simple thing: produce evidence against a specific magistrate and authorities investigate those issues. And this one coming from Dreamer King, he says, with the level of ignorance we see in our government today, we can clearly see Honorable Farah trying to speak for Parliament, but it's clearly exposed how much they are into the president's pocket. The judiciary is under attack. This one from Bobo Tieno says, I admire the boldness of President William Ruto, and sometimes it makes a good leader to make hard decisions in order for his agenda to be successful for the future benefits of the country, of his country. Ole Shongo says, whereas it's key that each arm of government should be independent, we cannot overlook the fact that there have been scenarios where one has tried to control others. It's evident that corruption has clearly impacted the rule of law and governance. Jaya Musoma says Kenya is slowly sliding into the path of anarchy. Executive and legislature must respect the principle of separation of powers that gives the judiciary a final say on policy formulation. Defying court orders or politicizing judgment sets wrong precedents. Brian Chemwa says President Ruto might not obey court orders because he believes in the executive privilege, asserting that certain matters are confidential and for national interests, and a perception that the court's decisions are sabotaging his agenda to Kenyans. The team Kenya says Kenya is suffering because money is being directed on non-issues. Politicians just exchange dollars and get kickbacks from multi-billion inflated projects. How can 3 million two-bedroom house be called affordable? And this one from Samuel Owoth, he says, people think industrial revolution is about going around putting in structures called industries. Housing initiative alone has given upper hand to Juakali industry, one of major sectors youths dwell in. It's not only employment on the sides. Sir Nixon Dugure says it is said that in law a man is guilty when he violates the rights of others. In ethics, His Excellency, he is guilty if he only thinks of doing so. This one from Star Zima 254, he says health sector wasn't doing badly, but you see interest of the executive every election is interfering with all these things. Rebe Butia says the judiciary cannot exist without the trust and confidence of the people. Judges must be accountable to legal and ethical standards. By holding them accountable, we must avoid invading the independence of judicial decision making. Samuel Ward says, I admire the onslaught by the president on the corrupt cartels within the judiciary. At no time has he said the entire judiciary is corrupt. There are corrupt elements and they are known. They know themselves too. On that note, we come to a close, and thank you for your time, Honorable Farah Maalim, MP, Dadaab constituency and a lawyer, for your contributions. And Bob Mukangi, who is a lawyer as well, and one of the key contributors to the current constitutional dispensation that we have. Thank you for your time as well. Happy New Year. And to the Law Society of Kenya President Eric Deuri, thank you for making time for the broadcast as well. And thanks to you too for waking up with us and watching the broadcast here on Citizen Television. When we get back from the break, our attention now turns on the second segment on health matters, the road to universal healthcare coverage, and we'll be speaking to two critical partners in that sector, Dr. Davdia Taylor, who is the Secretary General of the Kenya Medical Practitioners and Dentists Union, and also Dr. James Nyikal, the lawmaker representing Seme constituency and a member of the National Assembly's Health Committee. Gentlemen, thank you for your time. We'll see you again here. Certainly a very important topic. That discussion will be on and up after the break here on the broadcast. Stay tuned.